I am a litigation partner at Nunnally. I've been practicing for over 20 years now, and part of my function at the firm, and I don't know how I got this job, I wrote a memo and that's how I got it. I'm also the firm's general counsel, so I deal with ethics issues day to day just for our attorneys at the firm, and we deal with these privilege issues and deal with a lot of just internal questions on what do I do about this. So I guess I can kind of identify with y'all from that perspective on internal counsel roles and kind of some of the things we need to deal with. Although one would think it's a little more simple for outside counsel, more black and white, and I do think it is in many respects for a lot of y'all a little more complicated as in-house counsel and dealing with these privilege issues, and in particular the dual purpose communications. So let me get started here. So I'm sure you all know that, or many of you wear multiple hats, do multiple things for the business. You're converging on not just pure legal questions. There's business issues that come up that merge with the legal questions that you're helping your business units navigate. And so I pose the question, what is the difference between business and legal? Can we separate the two when you're advising your clients on these business and legal issues that are just inherently intertwined? I don't know if there's a difference. And I don't know if you can draw the line, and I don't know if you should draw the line. But one thing I can tell you is in preparing for this talk, it started to become very apparent that we often think of the attorney-client privilege as this steel wall that's just that cannot be penetrated. And we're taught that from day one in law school, the sanctity of the attorney-client relationship, and that should be protected at all costs, right? And so I think that a lot of us, even outside counsel, we get comfortable with putting things in writing and emailing our clients about the good, the bad, and the ugly of whatever issue they're presented with. And I'll tell you, my associate, Luke Collins, who's here, he helped me put together the presentation and did a lot of the background research. I think we both just came away just completely frightened on what we found in the case law. So I think if there's one thing that you'll go away with is maybe tighter butt cheeks when you walk out of here. But I think we have some points and some tips and traps for you to look out for and some things that you can do. But it's pretty much an imperfect analysis because you don't have a crystal ball and you can't second guess yourself and be scared of your own shadow as you're practicing law internally, right? You have to advise your clients and you have to tell them when it's down and dirty and ugly and get all that out there to address these things. So you gotta do what you gotta do, but I think the moral of the story here is that it's not an easy question on separating these two, business versus legal, and it can be a difficult question. And when you're in the heat of the battle and you're in it to win it, you can't be overanalyzing every time and every email that you're sending, but I think there are some practices that you can implement to help protect your clients and yourself if it does go south and if it does end up in litigation. So let's get started here. So I put the sands blowing there versus the steel wall, right? Because I think at the end of the day, someone may be looking over your shoulder if it does go to litigation. So I think you just have to watch out what you're putting in email and other written forms, and how you're conducting your internal meetings and who you're inviting and who needs to know what you're talking about as you advise your clients internally. So the origins of the attorney-client privilege is pretty interesting looking into this. I guess I had never really thought about it, as I went through law school and I've been practicing all these years. But I did read some scholarly articles about this that cited to some sources where it all came from. And many scholars go back to the Roman times and that it originated with Roman advocates being found in those times to be incompetent to testify against their own clients because to do so would be an immoral breach of duty of loyalty and thus unworthy of belief. So they're going to be discounted and not permitted to go against their clients, if you will. So it's kind of rooted in this idea of loyalty. And I think this concept, it's about protecting the client at some level, right? But even at this time, it really wasn't, I guess, decided per se on whether the privilege belonged to the lawyer or to the client or who really had control over it. But it's these concepts of loyalty and protecting the client at some level from their own advocates turning against them. And so then advancing to Elizabethan times in English law, kind of the same thing in some respects. Is the privilege was based on the lawyer's role and the lawyer having honor as a quote-unquote gentleman. And until the mid-1700s, English courts, granted such a privilege to gentlemen from testifying if such testimony would violate the promise of secrecy to, again, the clients. So here it's more held by the attorney in some respects, but again, it's still getting back to protecting the client and the secrecy aspect of the relationship between attorney and client. And so it was about protecting the client's interest in secrecy, and also, it's about doing damage to the lawyer's role as an honorable gentleman, as it were. And so we're talking about vows of secrecy being maintained and not broken for the protection of both. And then we advance to the time of the American Revolution. These concepts of honor and secrecy kind of rejected for a more pragmatic approach. It's a basis of the foundations of our modern concept of the attorney-client privilege, right? On making sure that the client can have open and honest communication with the lawyer. However, at this time, the privilege was found to be held by the lawyer and not by the client, interestingly enough. Now the focus has changed under modern law, and the privilege, as you all probably know, is held by the client, although the lawyer, as I'm going to talk about in a minute, can certainly assert it on behalf of their client. So here, this comes from a Hornbook definition of the attorney-client privilege as it's defined in modern times. It has to be where legal advice of any kind is sought from a professional legal advisor in his or her capacity as such, and it has to be communication relating to that purpose, made in confidence by the client, and it's at the instance of the client to be permanently privileged and protected, right, from disclosure by the client or by the legal advisor or lawyer, except where there's been a waiver. And so you'll see these concepts repeated in some of the other slides I've got to show you on the rules under the federal rules, which fall more under the common law, so we don't have it codified under the federal rules like we do in some of the states, such as Texas. Texas has a very strong codification of attorney-client privilege parameters, which is a good thing. So, is it a good thing, the attorney-client privilege? I mean, I think we all have been beat in, it's been beat into us since law school that it is something that is that we should all protect and that we shouldn't violate. But in looking at this and researching it, I mean, I did read some interesting articles where early on, I mean, it's been recognized for a while now in the 20th century. And obviously into the 21st century on the privilege being recognized for people, right, human beings, and then also as we've seen the law develop for companies and corporations, I think that's really where the rub comes in on who's entitled to the privilege at the corporate level, right? And so there are pros and cons, I think, and these are reiterated in the cases that you read from the United States Supreme Court all the way to a variety of state court opinions on why it should be protected. I mean, it's again about candor between the client and the lawyer, the client having comfort to talk to their lawyer and tell the lawyer everything, and to protect this concept of the sanctity of the attorney-client relationship, right? To allow the lawyer to be able to more effectively represent their client because they know everything. They can address, like I said, the good, the bad, and the ugly up front and deal with bad facts or bad law and have the freedom to communicate with the client about these things without fear that it's going to be exposed to the other side, right, if it gets into an adversarial situation. Again, protecting the privacy of the client, even the dignity of the clients, that embarrassing things aren't disclosed to third parties, et cetera. And again, it's reinforcing, and we'll see this in a minute when I get into some of the ethics rules. It's about the duty of loyalty, right, that the lawyer holds to the client And it's also about protecting the lawyer's role in the adversarial process so the lawyer can do a good job for their client, right? With having full freedom to navigate and not worry about things being exposed, right? Obviously. But what about the cons? I mean, are there cons to this protective rule that we have in place? I mean, and you'll see this as well. The courts are concerned with this. You will see that there's a concern about suppression of the facts and evidence that's necessary to fully adjudicate a dispute. And the suppression of the so-called truth. Now, of course, when you're looking at this through the lens of litigation, what the truth is, there's different colors to that. And the coloration comes in with the facts that are entered into evidence, right, on how the truth, quote unquote, is going to be perceived. And you'll definitely see this, and we'll talk about this on the Henry Grand Supreme Court case that wasn't. The courts are concerned with game playing and maneuvering, especially by the corporate entity. Less concerned by individuals. It's more transparent, or at least black and white in some respects, when it's, like I said, a human versus a complicated corporate organization with a lot of different people and objectives. There's concern that there's, just big bad corporations, right, have a lot of lawyers, have a lot of money to pay lawyers to cover up the facts, right, and to utilize lawyers in the wrong way to, again, suppress the facts and evidence that would be important to the other side that's maybe challenging those corporate, if you will, forces. So, and then of course, from the small guy standpoint on battling big bad corporate America, there's also a concern because in order to get the facts and evidence that you need to prove your case, if you're the plaintiff, you have to spend a lot of money and time and resources battling these issues in the course of litigation. And Lord knows I've litigated these issues frequently in the course of my career, where we've been on both sides of these issues. I do think that there are pros and that there are cons, and we just have to balance, and that's what most courts try to do. So again, like I said, it's easier when you're talking about a person, and a lot of the individual cases that you will see deal with things in the criminal context, where someone's on trial for criminal claims. And so it's a little bit more straightforward in that context, although there's gray areas as well there. But when we get into talking about corporations, that's where it gets a little bit more muddled. And the case history, it's only really, when you think about as long as our legal system and the body of case law that informs this whole discussion has been around, it's kind of recent. I'll talk a little bit about the Upjohn Supreme Court decision, the US Supreme Court decision that was decided in, I think it was 1980. That was really one of the preeminent cases that kind of put the stamp on it that yes, the corporate form or a corporation or a company is definitely entitled to the privilege. And the Upjohn opinion discussed, how far and wide the privilege was going to extend down for an in-house attorney or even an outside counsel dealing with employees and other agents in the company beyond just the executives, right, on investigating claims and trying to deal with things and talk to subordinates, if you will. So I think that first question is answered. Yes, it is entitled to the benefits of the attorney-client privilege a company is. And query on whether our in-house attorneys treated differently than outside counsel. I mean, no. I mean, you shouldn't be. And I said at the beginning, it's maybe a more complicated discussion for you, or more things to think about as you're conducting the business operations of the company on what might come out later. But I think we'll talk about the Henry Grand opinion. That whole case dealt with outside counsel. But interesting, it was kind of in the tax context, so they were kind of acting as tax counsel. And so it was kind of, again, dual roles as business and legal advisors. They were a firm that prepared tax returns. And I think that if I were a tax firm, I would think twice about doing that in light of some of the things that did come out in that litigation. So anyway, sorry it's so small here, but just generally, the Upjohn case, as I mentioned, it was 1981. It did put the stamp on it from the national Supreme Court standpoint, that obviously the corporation is entitled to that. And I will say, I have some slides on this as well on federal versus state. It is very state specific. So we can't talk about all of the 50 states' different little points of law on this. It would, that would take us days and days to go through all of that on each state's stance on exactly what the parameters are of the attorney-client privilege as well as the work product privilege are. But Upjohn, decided it for federal courts under federal common law, and it rejected the control group test and adopted the subject matter test. Which I think is definitely the better test from the standpoint of protecting the privilege and allowing the lawyer to do what is necessary without fear that their investigation and communications with subordinates that are involved in whatever trouble they've gotten the company into, they can fully investigate and do what's necessary. And so it's taking the subject matter of what's going on and looking at all the facts and circumstances versus just looking at who the lawyer was communicating with and if they were in what they called the control group, being the executives who controlled the company, as to that group being the only group that was entitled to the protection of the privilege. So Upjohn set the standard, and many states followed that standard once that opinion was issued. And oh good, the punching bag worked. I was worried that the meme wasn't gonna work. So that's you, dealing with all of these different standards. So you have federal standards, you've gotta look at that, and you have state standards. And there are a plethora of complicated and complex choice of law issues, especially if you're seated in the legal department that oversees a national group of employees, right? You have employees all over the country. So what you're doing and what your team is doing, it's really going to be driven by the applicable law in the applicable jurisdiction. So you got to know the law and know what's happening, where the issue is, who you're communicating with, and just think about those things and know the law in your jurisdiction. And I think, again, the moral of this whole presentation is that the attorney-client privilege may not be, sacrosanct as you thought it was. And you just can't assume that it's going to be protected just because you're the lawyer and you're talking to your client. And okay, so this is Federal Rule 501. It talks about the common law, so it doesn't have all the codification and all the elements like the Texas rules do. And here you can see that it's, they're going to look to the common law, the courts will, in light of reason and experience, and they're going to apply that to a plethora of privileges that fall under this rule, including the attorney-client privilege. And interestingly, in that bottom note there, it says, but in a civil case, state law governs privilege regarding a claim or defense for which state law supplies the rule of the decision. Okay, fine, but what if you have a case where it's mixed? It's probably going to be federal privilege law that will apply. And generally, if you're looking at whether or not work product is going to be covered, it's generally going to be federal law that will apply. So it's truly a complex analysis on looking at these issues. And a lot of times, you're not going to be doing this analysis when you're just typing your email to your client about, the issue of the day. But it's something to be aware of on just knowing that there are different jurisdictional differences that you may have to navigate. So here's Texas law, and I'll talk about this in a minute. Texas has a little bit more of a blanket privilege, and maybe that's why all the years I've been practicing in Texas that you just feel like, well, it's protected. It's between an attorney and client, no problem. We can say what we want. We have the freedom to do that. But even so, it doesn't follow some of the more nuanced review that federal courts are apt to undertake, even in the Fifth Circuit, and I'll talk about that more in a second. But even here, under this test, you can see here that it's the client that has the privilege to refuse to disclose and prevent any other person from disclosing confidential communications, again, made to facilitate the rendition of professional legal services to the client. Now, although Texas has a broader view of this in many respects, when you get right down to it, it's going to be a very factually intense analysis if this gets litigated on whether or not the client per se was communicating with the legal professional to facilitate the rendition of legal services. So I think even the use of legal services broad, because we do business stuff all the time for our clients, right? So you can see and you do see these things debated in the case law when someone wants to fight the issue hard enough to get there to try to pierce through to get to these confidential communications, or what we thought were confidential communications. And the rule goes on to codify that it's between the client or the client's representative, right? So that includes the employees, et cetera, the agents. So we have agency here as well as under the federal common law. And it also covers the lawyer's representatives, right? So you're protected there under Texas law. So there's some special rules under criminal cases that we won't get into, but you can see here for the criminal rule that it's not only just stuff your client told you, but it's stuff that you learned in the context of the case. And that kind of mirrors the ethics rules on confidential and privileged information. It's broader on what client confidential information is. It's not just privileged communications. It's all the stuff that you've learned in the litigation that you do have a duty to protect. And so here again, the rule specifies that it's the client that claims it, but it goes on to say at the bottom there that the person who is the client's lawyer or lawyer's representative when the communication was made can claim the privilege on behalf of the client. So here are the exceptions, right? And these exceptions generally also found in federal law. And the one that I will point out is the crime fraud exception. And I wonder why that's kind of sticking in my mind these days. So all you need to do is look in the headlines to see this, and you go, wow, he had to turn over his notes. I'm talking about the Trump DC opinion or case. And we try to pull some of these opinions, but a lot of the stuff, it's sealed, so you can't get into all the dirty details of what's gone on, other than we know that Trump's lawyer was ordered to turn over his notes, and he even had recordings of stuff that he had to turn over. Because I believe the court found that there was enough, not to say that she found this, but there was enough to justify turning it over because potentially he was used as an instrument of crime or fraud. So scary stuff. And I don't know why he would have made a recording of his meetings or telephone calls with. But I mean, I think maybe we do know why in some respects, right? What we know about what happens to the lawyers. Sorry, not to get into that, the politics of it all. But anyway, it's a good example of some scary stuff for lawyers on things getting turned over, and wowza. So the difference here, like I was saying, the ethical rules, and I'm talking about the Texas as well as the ABA model rules, again, it's you have a duty to not disclose client confidential information, which is, it includes things beyond attorney-client privilege here. So it's privileged and unprivileged information, right, that's protected. This is the Texas rule. And it incorporates 503, which we've just gone over, and 501 under the federal rules. And unprivileged client information means all information relating to a client or furnished by the client other than privileged information acquired by the lawyer during the course of or by reason of the representation of the client. So that includes a lot of stuff that you've got an ethical duty to protect and not disclose. And same thing, this is the ABA model rule. A lawyer shall not reveal information relating to the representation of the client unless there's consent or authorization, and there's other exceptions here. So again, this is the Texas rule exceptions. Again, authorization and fully informed consent. And of course, for crime fraud, And then, to rectify the consequences, if you know about it, you got to do something about it. And then there are some exceptions for unprivileged information that are a little bit broader. You have more leeway there under the ethical rules, right? And then, of course, if you know that the client is likely to commit a crime or fraudulent act that is likely to result in death or substantial bodily harm to a person, the lawyer shall reveal the information to the extent it's necessary, reasonably necessary to prevent the client from committing the crime or the fraudulent act. So you've got some duties there, and hopefully you never have to face a situation like that. So similar again, exceptions under the ethics rules, okay, on the exceptions to your confidentiality duties to your client from an ethics standpoint under the ABA rules. They're generally similar. There's maybe a few small differences here. So okay, so the main show here, the In re grand jury Supreme Court decision that never was. So I'm going to give you an overview of what happened down below in the lower court. And then we can talk about why it's important and really what you need to know, what this case can teach us. So it originated out of the Ninth Circuit, Central District of California. There was, again, as I mentioned, the tax law firm, outside counsel, that was involved. There was a federal grand jury subpoena that was sent to the firm to produce records, including tax returns prepared by the law firm, along with other documents and communications. And the law firm did advise the client, its underlying client, about tax law issues that were arising upon expatriation, and they prepared the tax filings required when a U.S. citizen expatriates. So the district court did, and it's really kind of amazing what this court did, very hardworking court out there in Central California. I believe that there was like 1,700 documents that were parsed through, and the court, said this is clearly privileged. This over here is clearly not privileged. And then there were about 50 documents that the court went through line by line. And we don't know what all the line-by-line documents or what was said in those lines or what the documents were. It's all under seal, so you can't get in there and tell you exactly what they were looking at. But there were 50 disputed communications and documents where the court found that there were dual-purpose communications where it was business and legal at the same time. So the court ultimately found that based on the test that it applied, it ordered the production of certain of the dual-purpose communications under what is known as the primary purpose test. And so the court looked at, so what was the purpose of the communication? Was it business or was it legal? And so the test is, what was the apex purpose of the communication? Was it seeking legal advice, or was it a business communication talking about business issues and business advice? So it's a very fact-intensive analysis on this, and I think it could turn out differently based on the judge that you pull, on whether they're going to think that the primary purpose is legal or business in any given situation. So the law firm, their counsel argued at the lower court level, or actually at the Ninth Circuit level, they argued on appeal that the court should not have applied the primary purpose test. Rather, they argued for more of a work product privilege test for attorney-client privilege, that if the communication was created because of because of the idea of seeking illegal advice, that it should have been protected, because it was the purpose of seeking the legal advice was because the law firm or the client needed the legal advice. Kind of a circular argument, if you ask me, and maybe not all that germane, because when you talk about work product privilege, that's the anticipation of litigation privilege, right? There's usually some markers when you know that litigation is on the horizon, and so that protects more than just the attorney-client privilege, right? It protects your other documents that are created, your thought process as the lawyer, and even the client's documents that are created and other communications that the client may be undertaking even without you being involved that are in anticipation of litigation, right? So the Ninth Circuit applied the primary purpose test, agreed with the district court's decision-making process on that, and they adopted the primary purpose for the Ninth Circuit. So the law firm appealed to the U.S. Supreme Court, and cert was granted. There was briefing on, obviously, the cert process, and then merits briefing was taken. And there were like 13 amicus briefs that were filed. The ABA, of course, weighed in. There were a lot of other bar associations that weighed in, all in favor of a broader protection, if you will, for the attorney-client privilege to, again, protect the sanctity of the attorney-client relationship and the foundation of our profession. And then oral arguments were conducted earlier this year, and everyone was so excited. All the legal magazines were just tittering about how the Supreme Court's going to make this new decision that's going to really help clarify this supposed circuit court split, right? Well, after oral argument, and it's pretty interesting that Luke and I read the transcript, so it's pretty interesting. The court ultimately, 2 weeks after that, they dismissed the writ or the cert as improvidently granted, which appellate lawyers call a dig, which I think is kind of silly and interesting that they call it that. But yes, so there was a dig in this case. It's rare that this happens, but this is what happened in this case. So when you look at the transcript, you can see that the justices, pretty uniformly, I mean, I didn't see really anyone that was really worried about the test that was being sort of broadly applied, which is the primary purpose test. We have, and I'll talk about this in a second, I've got a slide on it, there was an opinion out of the DC Circuit that adopted maybe a more reasonable test. I don't know, Kavanaugh wrote the opinion when he was sitting on the district court, or the DC Circuit, that's a little bit more, protective of the privilege. But generally, the advocate for the law firm who, wanted to adopt this broader test, do away with the primary purpose test, or at least establish it from a national standpoint, he had to admit that most state courts and courts, district courts and other circuits they're kind of doing this. Now, whether they're actually deciding that it's the primary purpose, okay, fine, because once you kind of get in there, it's maybe a little bit more nuanced on the decisions that the courts are making based on the facts. But generally, that's what they're calling it, certainly, the primary purpose test. And so I think the justices were just not that interested in kind of changing the status quo, and I think they went back and thought, this is my personal opinion about it, that they went back and thought, what do we need to do here? We don't need to change anything. It's fine the way it is. So no one really knows really why the dig was done here. And again, like I say here on the slide, perhaps the justices thought it was fine, the status quo was fine, that there was no need to really change things, that maybe there really wasn't a circuit split, actually. And also, this case was very tax specific in the tax law context. And also, like I said, a lot of things were redacted and then sealed, so you can't get in there to really understand the extent of the ruling when you publish the opinion, because it's sealed up. So, okay, yeah, the circuit split, right? So prevailing test is, or prevailing view in most of the federal circuits and in most state courts is the primary purpose test. Now, except for Texas, because it's Texas, right? So the primary purpose test, was applied to dual purpose communications in the Ninth Circuit. That has stood, right? The Supreme Court did not change that. And then we have a significant purpose test that was applied by Kavanaugh, as I mentioned in the DC Circuit opinion. That's the Kellogg case. And Kellogg was not a real tax case. It was kind of an internal investigation case. And I think there, the government was trying to pierce in and trying to argue that they should get the internal investigation materials and all the communications because the investigation was done, I think, at the behest of an insurance company. So like the investigation was done for like business purposes. And so they wanted to pierce into all the communications because they said, well, it was done for business reasons, not legal reasons. And Kellogg and Justice Kavanaugh rejected that and said, no, as long as there is part of the reason for the communication is seeking legal advice. So if it's one of the reasons for the communication, then it should be protected. So it's a little bit broader, obviously, than the primary purpose. That's the singular purpose of the communication. So it's more mixed and it's more protective. And so ultimately, that's kind of the test at the end of the day that the advocate before the U.S. Supreme Court, the law firm's lawyers were advocating. By the time they got to oral argument, they kind of fell back on that. Probably a smart move since Kavanaugh was sitting there. So then we have the most narrow test applied, and that's the Frederick case out of the Seventh Circuit. Good old Posner wrote this opinion back in 1999. So again, this case, it's arguable that it's only applicable in the tax return context. And that's what it says. A dual-purpose document, okay, it does say dual-purpose document, doesn't just say tax return, but they were talking about the tax returns. A document prepared for use in preparing tax returns and for use in litigation is not privileged, okay? So the tax return, if the law firm prepares it, and then the underlying documents that support the numbers and things that go into the tax return are not going to be privileged. And that's generally across the board what we're talking about. Of course, it's the Ninth Circuit did apply a little bit more broad test, right, with some of the communications, but that case wasn't just limited to the Henry grand jury case out of the Ninth Circuit. They weren't just talking about the tax returns. They were talking about communications and other documentation beyond just that. Whereas in Frederick, it was more limited to the tax return and the underlying documents supporting it, where the court found no, there's no privilege. And part of that is because there's no accountant privilege. And so, if you're a lawyer and you're an accountant and you're kind of doing both, the court, again, didn't want the lawyers to be hiding behind the privilege to protect information that should come out regarding the tax return. And I will say, in the oral arguments for Henry Grant, again, the justices, they were grilling the advocates on using the attorney-client privilege for gamesmanship and maneuvering. So there is a broad-based concern amongst the judges, as I mentioned at the start of the presentation, about that. So judges are looking at that and they're analyzing things. And I think the scariest thing is that your emails may be analyzed line by line at the end of the day. And so you don't know what's going to come out or what will happen in any given situation, if there's going to be litigation or not. So you just have to be careful about what you are putting in writing. And yes, okay, great, thanks, Karen, that's great advice. But you just have to be aware of the environment in which you're operating in, so you can make at least an informed decision about what you're putting down in an email, in particular in the written form. So obviously, this is where we have the overlap. I think that goes without saying. And then, so Texas versus the Fifth Circuit, I touched on this a little bit here. Texas is going to do their own thing. It doesn't apply. We do not apply the primary purpose test here. It extends to the entire communication, and you'll find a lot of law on this. But as you dig down, like I said, if you dig down into some of these opinions, you might find some squabbles about what will qualify and whether it is if the communication with the lawyer was for just solely a business purpose. So it's not like it's just, oh, you're good, there's no worry in Texas, because there can be situations where that is litigated. But there is case law. This quote right here, it's a quote that comes out of a case that says that the subject matter of the information communicated is generally irrelevant in Texas, although I won't say blanket that that's the case, and like I said, no worries. you still need to be thinking about this, particularly when you're in the Fifth Circuit. I mean, do you know where you're going to be, if you're going to be in state court or federal court when it comes time? You probably don't know that. I mean, maybe you do. Texas, or the Fifth Circuit does follow the primary purpose test. And again, it mirrors the general federal standards, their federal common law standards. Again, the primary purpose of securing a legal opinion or legal service or assistance in some legal proceeding. And that's easier if you're communicating about ongoing litigation, like I said. So these are just some nuggets, and we don't have to go over all of them, but some of them are just they're great because it'll really get you going and really thinking about your role as an attorney and what may come out after the fact, right? So there's no presumption that a company's communications with counsel are privileged. Oh, I always thought it was pretty certain, right? So it's vital to the claim of the attorney-client privilege that the communication have been made and maintained in confidence. Okay, fine. You don't want to have outsiders or other people. I think the best one on that is where others are copied. Your clients are going nuts on copying people, and you just put some real important legal advice down below, and then they're copying people that are outside the company. So that's busting privilege right there. So you've got to coach your team, and I've got some pointers on that as well on not doing that. Confidential communication between client and counsel is privileged only if it's generated for the purpose of obtaining or providing the legal assistance. We covered that. That's part of the primary purpose test. Communications by a corporation with its attorneys, who at the time is acting solely in his capacity as a business advisor, are not privileged. I mean, these are, like I said, direct quotes out of, this came out of the EEOC versus BDO case in 2017. I mean, it's like this opinion summarized the law here. This is a classic, right? We'll just CC in-house counsel, I'll be privileged, right? No problem. No, that's not the case. A CC is not going to cut it. And maybe it will, maybe you don't have to put it up, maybe you won't have to put it on a privilege log. If in Texas it falls, after the date of anticipation of litigation, there's some rules on that that will protect you from having to disclose it, but maybe it's not, and you have to put it on your privilege log, and so someone may say, I'm going to push on that. And then, I have some advice on and some pointers on, well, you should put attorney-client privilege on there, but just putting those labels on there, that's not enough either, right? It's just conclusory at the end of the day, and you may be before a federal court that's going to do a line-by-line analysis. Okay, yeah, and then again, where you have a mixed discussion, I think that's where the rub comes in, where there's a mixed discussion. And maybe you can separate it out. I mean, y'all would have to decide and think about it on whether you can parse through it and maybe put the business advice here in one email and put legal advice, the super dirty, bad stuff that you're going to tell them about the situation, put that in a highly confidential email and not mix the two together and fire it off. Or maybe just pick up the phone, right? Or go down the hall. So, and again, the quotes from the case law here, it's a highly fact-specific inquiry on whether the privilege is going to apply. And who has the burden? You do. You have to prove the privilege applies. Your opposition in the case, they can shoot holes in you all day long, and you have to overcome all the bullets that are being fired at you to make sure the privilege sticks. So it's your burden. So you have to be prepared to support it, right? With like evidence and affidavits and stuff that will support your assertion of the privilege. And then here, oh my God, if ambiguities on whether the privilege applies are decided, they're construed against the proponent. So if there's any question about it, it's construed against you. Not like, well, we think it should apply, and we want to protect the sanctity of the attorney-client relationship, so we're going to protect it. No, it's opposite. So, and again, it goes back to all the pros and cons that we talked about. Because the attorney-client privilege has the effect of withholding relevant information from the fact finder, it is interpreted narrowly to apply where only necessary to achieve its purpose. Okay, and I think we don't have a lot of time to really dig into this implied waiver, but I thought this was like super scary. And I've litigated this issue, and luckily I was on the side that was piercing into this issue. So if you're going to assert a defense that's going to partially rely on communications or documents that you're claiming are protected by the attorney-client privilege, and then you're going to assert a defense to say, well, like the classic one is advice of counsel, right? Well, you can't assert advice. I didn't know I was wrong because I was relying on advice of counsel. Well, the advice of counsel is going to be disclosed. They're going to be able to get that. And I was just looking at a recent Sixth Circuit opinion on this. The in-house attorney, there was a data breach of some kind, and there was a lawsuit, someone sued over the data breach. They hired an outside consultant to look at what happened with the data breach. The outside consultant determined, well, really what happened, it was the plaintiff's fault. They messed up on their side, and they did things wrong. So in the litigation, the company, the defendant, asserted, well, it was the other side's fault. You know, their acts and their own negligence caused it. So the plaintiff asked about the defense and discovery, and then they asserted this report, and then, well, the plaintiff wanted the report, and then said, no, it's privilege. We this is work product, and our attorney had this done. The court ordered it produced. You can't rely on it, and it's this concept of sword and shield. You see those words bantered about in the litigation or in the case law. You can't use it both as the sword and the shield, the privilege. So anyway, and so the cases here, this is, again, Fifth Circuit case law here. You can look at that. And if you all want a copy of this presentation, I'm happy to give it to you. If the ACC doesn't make that available to you already, just let me know. Similar standards under Texas law for implied waiver. And again, work product privilege, again, it's broader, like I was saying. It's not just communications. It's more protective. But maybe easier to apply in the sense that you might have markers where you've received a demand letter, that kind of thing, where you can say, all right, I got the demand letter, we're applying anticipation of litigation from this point forward, right? So again, it's very similar standards under federal and Texas state law. There is a rule that's codified under the Texas rules that talks about this on what's anticipation of litigation. And it's, whether a reasonable person would have anticipated litigation under the circumstances, and whether the client trying to keep the information confidential believed in good faith that there was a substantial chance that litigation could happen. And they made their notes, communications, et cetera, to prepare for that possibility. And then we have core and non-core. Really work product. A lot of times we talk about, documents reflecting the attorney's thoughts and opinions, and their work on preparing their client's case for trial. And then we have non-core, and non-core doesn't necessarily reflect the attorney's thoughts. And there are exceptions for non-core, but it's pretty rare, and you've got to have a really good argument for why you would need to get into those communications. The opposition has to show that there's a substantial need to prepare its case for trial, and they're unable to obtain that information by any other means without undue hardship. And so it's a pretty tall order and tough test to meet, but it can happen. So, that's us crying in our offices, right? And then, okay, do and don't, here are the tips and traps. So, you can't predict the future, right? You've got to try to take the conservative approach as much as possible, try to know the law in your jurisdiction, and just know that it's not locked down, okay? It can happen. It can and it does happen where it's gonna come out. So someone might be looking over your shoulder after the fact. If only we had a crystal ball. So I think, like I was saying, avoid mixing business and legal as much as you can, where you can figure it out on what you're doing. Like I said, try separate communications. Maybe and then if your client's like, I can't take all these legal emails, it's too much, and you need to put it all in one, try to do sections, because one might be redacted and the other not. And again, like I said, consider a telephone call or an in-person. And then I said, well, they could do it via Zoom, but then, what if someone records the Zoom? So make sure it's not being recorded. And so you just have to coach your business counterparts, right? And I think it is a good idea, because if something comes out later, and things get produced or they're subject to production, to have that moniker on there, protected by the attorney-client privilege, or protected by the attorney, or it's work product, anticipation of litigation. But I think going further than that, maybe putting even further protective language, if your team's coachable, to say, I'm writing to seek your legal opinion and advice on X issue, right? Whatever that may be that's affecting the business unit. And you need to tell your business counterparts the consequences of what that means to waive, the attorney-client privilege, what that could mean, and the importance, obviously, of keeping your advice confidential, in writing or otherwise, not blabbing to, everybody that's not in the company or within the bubble of privilege, right? And then try to get, your legal team to use the same monikers when they're communicating with their team. And use things like, you requested my legal opinion and advice on X issue. This email summarizes my legal opinion and advice on this matter. And then maybe you want to have them say, do not forward this, or say, do not forward this email. Maybe say, don't forward at the top. But of course, when you put that on there and then they forward it, that's pretty clear that it's waived. So you would have to judge with what you're dealing with, in your situation. And figure out if it's a need to know, like, do they need to be in the meeting for in-person meetings? And try to advise in advance, what the purpose of the meeting is, so everyone's informed, and then you can ferret out if somebody doesn't need to be there, that kind of thing. I think I covered copying third parties. Watch out for autocorrect, haha. And then again, like I said, it's your burden. You've got to document, you've got to prove it if you want to have the benefit of the protection. So don't screw it up, okay? I think that's it.